Good afternoon. This is Attorney Don Nguyen. I'm working today in English, so it's kind of nice for me. I don't have to trying to translate everything from English. Today's topic is small businesses and how do we defend from the small claim cases. In order to do this, I'm going to go through the procedural aspect of the small claim, what it is, and all that stuff. And then at the end, I'm going to talk about how we deal with the situation where we're being sued by a client or a competitor or something like that in a small claim situation. Understand that I'm talking about Iowa here and not Minnesota. Minnesota doesn't have a small claim per se, but they have a $10,000 limit for a conciliation project or procedural. So this is mainly Iowa. It's pertaining to some other state too, but mostly Iowa. Next slide. Okay, and normally the speaker information is Ying Sa. Ying Sa is a very good accountant. He's very experienced and have extreme knowledge in all things have to do with money. And I'm not so much with the money, but I work with Community CPA, and I'm with DocuServ.com, and we work very close together. And the website is communitycpa.com. If you need anything regarding accounting, payroll, anything else that you need done, please consult us. We have offices in Iowa City, Des Moines, and Minneapolis, I believe. So we multi-state, and we also have clients all over the country. And actually the world. We speak 8, 9 different languages. So if you call, please let us know, and we'll do our best to help out. I'm their counsel for the firm, so I help with the legal aspect. But we got to take with a grain of salt. As I always say, with these seminars, they're not actual legal consultation. You can't say, I'm doing this because Community CPA or Don Nguyen told me online to do that. And we don't have the representation for to do this on the wholesale aspect of everything. So we need to do this to put the disclaimer in. This is for informational purposes only and not for legal use. If you want to consult with an attorney of your choice, you're welcome to do that. But just understand that we're doing this as the benefit to our clients and to the public and not a legal service. Okay, well, the definition of small claim is small claims. Each state has a definition of how much the maximum is you can file a small claim for. It's a lawsuit in a special court that allowed the parties to negotiate and to litigate the amount that they think the other party owe or whatever it is that after. The reason that the small claim court was made because it's so costly to litigate through normal court, which can involve up to millions or even billions in history. So in order to use the superior court, the main court, for a small claim is a waste of money and resource, and small claim could be much faster to litigate. The time is shorter, and the procedural aspect of it is much easier. And normally you don't allow for discovery in small claim, or you are, but it's limited to and the party have the short time to do that. Discovery is the process of trying to figure out what's information the other side have that may help your case or even hurt your case. They will provide to you. But it's the limited jurisdiction, so there's also limited rules and regulation and court procedure. In Iowa, it's $6,500 below you can file in small claim. You could file in small claim. It doesn't mean that you cannot file in superior court. You're welcome to do that. I mean, if you have $20 litigation and you want to do it in superior court, it's up to you. It'll cost a lot more to do that than to get back. But you as the litigant, you got to make a decision of where to take this. But for my client and over the years, I encourage people to litigate in small claim if the amount is under $6,500. Small claim court in Iowa also are being used for litigation of forcible entry and detainer. That just means that eviction. Okay, so landlord can file an eviction, and within the small claim court can evict people out of the rental place. And the reason they do it in small claim in Iowa is because, once again, it's a lot quicker and it's being decided because time is such an essence in an unlawful detainer case. And the small claim can resolve these a lot better. And in the small claim, whether it's for eviction for money judgment, is tried before a judge, a commissioner, an officer of the court appointed to do this. Normally not a judge, a superior court judge, not a full-on judge. They can do it, but most of the time the counties would save money by having commissioners or associated judge to do this kind of work. Okay, to start a small claim case in Iowa, there's a requirement for electronic filing. Okay, so the old days, you fill out your paperwork and you take it to the court and you give it to the court, and then you start from there. It's a lot easier now. I mean, people are scared to file electronically, but it's so much easier. You can sit at home in your underwear and file it. It's great. You have to go to the Iowa Judicial Branch. They have the forms, the fillable forms in there. You don't even have to sign it. You can sign up for a e-file account, and then you can use electronic signature. You can pay for the filing fee, which is $95 for the small claim, and send it in PDF form, and and pay with your credit card, and everything's online. The court in Iowa and most county also provide for service. You don't have to take it to the sheriff or a process server and say, here's some money, give it to that person. Obviously you can, but especially in Polk County, they provide for a certified mail service, which the court will send directly the complaint from the court to the defendants. So once the proof of service come back, the proof of mailing come back, and the signature is there, it's as good as proof of service as a personal income, as personal service. Of course, if somebody refused to take it, if the address is bad, you can always come back and serve it personally. The service is not free. The court charges, I think, a certain amount. I think it's maybe $40 for service of each party. Okay. Okay, next slide. And I'm skipping the answer on purpose, okay, to put it at the end of this talk to see how small businesses and people deal with the answer once they get served. Once they get served, the court will set a hearing in front of a judge or commissioner for the claim. The party will then have a chance to be in front of that judge and talk about why, you know, the motion should be granted, the money should be spent. The magistrate hear the small claims, so, and most of the time, they're not lawyers, people who are not trained in the legal profession, so it tend to be formal. That's not to say that the rules of court doesn't apply, because when a lawyer comes into small claim, we always object to the hearsay. We use the evidence rules and all that stuff. So it's an advantage for you to have a lawyer doing this. But for the most part, it's pretty relaxed, and people sit in their own spot and they talk to the judge directly instead of being in the witness stand. The procedure is not recorded unless some party requests that. And if they want a court reporter, they have that party who requested have to pay for it. It can be recorded by other means. If you have served, next one, failure. If you have served and they do not appear for the court hearing, as a defendant, you will get a default. That means that the plaintiff wins automatically. That's whatever they ask for, the court will give it to them, you know, whether it's money or in the case of unlawful detainer, they have to move out of the place. But if the plaintiff doesn't appear, which happen all the time, they file and they just don't appear, the defendant can ask for the judge to dismiss the case with prejudice. With prejudice means that it cannot be filed again. Without prejudice, they can do it again. With prejudice, your case is done. You're done. You cannot file against this defendant for the same incident again. Okay. Next one. We're going to talk about this for default judgment. We already talked about judgment. Okay, next one. Okay, if you get a default judgment, a lot of time people made a mistake on the court day, inadvertently skipped the hearing, was surprised, there's some kind of excusable neglect, something that you can make a motion to the court and say, Judge, I'm sorry, but you know, I have a sickness in the family. I didn't get the proper notice. I didn't see the court day, whatever excuse you can come up with. Then you can file a motion to set aside that judgment. That just means that, say, we'll take back the judgment that was filed in the default. And the party can litigate again, just like that default never happened. But it has to be filed no more than 60 days of the entry of judgment. So you need to file immediately as soon as you find out there's a judgment against you. Okay, appeal. Next one. If you want to appeal the decision, you have to file a notice of appeal and pay the clerk of court the docket fee, and then it will be moved to district court. Okay. There are cases where, and it turned into a normal case. To this district court, we decide to appeal. Upon looking at the case without taking any additional evidence, the action could be appealed, and it may go all the way to the Iowa Supreme Court to do the cases if it's a normal case. In small claims cases, though, the Iowa Supreme Court has the discretion whether or not to hear the case on this kind of situation. Next one. Assume for a second that you win the case, either to default or to the trial. It's difficult to collect. You know, the old saying is you can't get blood from a turnip. It's true with this last small claim cases. You're waiving a judgment. What does that do? Well, in Iowa, it's very powerful because it will be recorded under your name or any property you have. So with that judgment will follow the defendant until it is paid. And every time he or she's trying to sell a house, buy a house, it'll kick on because when they do a title search, they're going to put the name in, and they're going to say there's a judgment, that judgment need to be paid. But most of the time, we're going to try to collect from that. Okay, it's through garnishment. You can attach people wages. There's a whole industry, collection agency and lawyers who do judgments and collections. They take a large chunk out of the judgment, whatever they collect. Doesn't have to be the whole amount. Say if you have $1,000 judgment, they came in, they negotiate with the debtor, and they got $500. They're going to take a large chunk of that $500, not the $1,000. So they want to get as much as possible, but they also have the right to collect less to negotiate the payment. You know, something is better than nothing. If you are the defendant and there's a judgment against you, there's things that you can do to prevent them from taking all the money you have, including, you know, financial hardship and things that's in your account or from your work that will cause hardship for you, or if you're handicapped and things like that. So if you are in financial trouble and there's a judgment against you, please consult a professional trying to resolve that. It'll be much better for you. Also, there's any judgment, whether it's $1 million or $20, can be discharged by bankruptcy. And people after this pandemic may be looking at that, and we're looking for a surge of bankruptcy. But without the help from the federal government and state, we don't see that right now, but that's another thing to do. Next slide. Okay. This is why I want to talk to you about defending small claims. I have many businesses who are my client who are being sued by their clients, their customers, for things that really not worth suing. But I have a gentleman who has a car repair shop, and often he's sued for not doing the repair and not giving the refunds. And the man is a very gentle and very reasonable person. And every time there's something wrong, he gives the money back. And if it's his fault, he'll fix it. But then so it's always some people that will come and trying to use the small claim system to see if they can get more money out of the business than they're entitled to. So as a small business, you got to think about your reputation, not your reputation in the marketplace, as your reputation as lay down when somebody come after you, or somebody, you know, not being fair to you. The question you have to ask yourself is financially, is it worth it for me to do this? Okay, if somebody sue you for a couple $100 and drag you to small claim court, you're gonna have to take time out of your day. You're gonna have to answer the lawsuit, and you eventually have to settle this one way or another or go to trial. Is it worth it? On the other hand, if you just pay the $200 and not fight because you don't think you owe the $200, then the reputation is there. There'll be other people who say, okay, I'm just going to sue them just to make some money out of this case. Okay. So that's the decision you have to make. Once you're served with a lawsuit with a small claim as a small business owner, you look at it and see, okay, what do I have to do to get rid of this? Is this guy halfway reasonable? Okay, he think I owe him $200. I think if I can give him $50 refund, $100 refund, he'll go away. Then do that, but don't just roll over. Okay, I don't care how much the amount is, because that reputation is there, and there are people out there who take advantage of you. The next question is whether or not it's worth it to hire a lawyer to represent you in the small claim. Is you in Iowa, you are allowed to do that, because a lawyer can file the small claim and can represent you in a small claim. In state like California, they are not allowed anywhere close to the courtroom in terms of representing their client in a small claim. They can give a consultation and go through the material and all that stuff and prepare their client for a small claim case, but they can't be in the courtroom. They can be in as a witness, but that's about it. So once again, the question remains, if I'm being sued for, say, $6,000, do I need a lawyer for that? Yeah, for that, you probably do, because the people, there's enough money at stake that you can do that. And people with lawyer in small claim have a real advantage in the cases and to litigate it in the trial. Because, as I talked about before, it's a very relaxed, very informal hearing. On the other hand, the rules of law, the evidence, the civil procedure, everything still apply. When you litigate as a pro per, as a person, not a lawyer, you assume to have all the knowledge and everything else that the lawyers has to litigate. So it's a real advantage. Okay. Back to that gentleman with the car repair shop. I represent him every time he gets sued. And we go in there and we kind of litigate. And every time there's also something wrong with the lawsuit. They sued the wrong person. Instead of business, they sued the guy who did the repair. They didn't have any proof of repair. They didn't have no proof that the repair was done wrong. Everything fumigate into a bad case. But if you're not a lawyer and you're in front of the judge will not tell you that, because the litigator's supposed to defend himself, and not the judge only rule on what evidence he or she has. So for what it's worth, I think it's worth it for a lawyer to do the litigation in the case. Now, to defend yourself, you got to prepare. If you don't have a lawyer, you had to prepare for the hearing, okay? Number one, show up for the hearing on the date and the time. Remember, I said that if the plaintiff doesn't show up, you ask for the case to be dismissed with prejudice. If he does show up, do your homework, bring exhibit. In Iowa, in most counties, you have to file the exhibit prior to the hearing. With COVID and everything, you cannot bring a stack of paper and say, these are my evidence and these are the things I want to show the court. It has to be filed with the court prior to the hearing. That means the other party who also have access to the same case have to have a chance to read through the exhibit before you have the court. So and then ask the question to the litigant to your favor. Okay, you can lead them. And lead them, it means you ask the question that you already know the answer, the yes or no answer. Is it true that I already pay you $500 of the $600 you asked? Is it true that the repair you did not have any complaint for the first 5 weeks? Is it true that the delivery was done on time? All those things that you want to ask when they litigate. And if you lose the case and it's a fair case, I think you should pay it. That's the part of the reputation too. Okay, just a quick overall the small claim system. So I hope it's helpful to people, and I hope to see you the next time. Next slide. Okay, so you have any question at all? If you want to see if you can get in touch with me or have any question regarding taxes and everything else, please call Community CPA at 515-288-3188. 3188. We're open Monday to Saturday, 6 days a week from 8:30 to 5:30 p.m. and we're always there for you. Thank you for taking the time. I'll see you next time.